Good morning, everyone. Welcome to Landmark Chambers webinar series on water management. This is the second in this series, and we'll be dealing with nutrients in water, pollution and house building issues. We're tackling principally the difficult issue of nutrient neutrality and the impact of pollution from particularly nitrates and phosphates on protected watercourses and its impact on development, and the struggle that has ensued in attempting to deal with these issues and to find ways in order to enable development to proceed and at the same time preserving important ecological resources. We're delighted to see so many of you today joining us, and we hope you'll find our presentations interesting and helpful. My name's David Elvin. I'll be chairing the session and I'm being joined by my colleagues, Jacqueline Lean and Alex Goodman, who I'll introduce before their presentations. We'll begin with Jacqueline's presentation. Jacqueline was called in 2007. She has the classic landmark practice, which encompasses all matters concerning the use and development of land. She's significant experience in planning and infrastructure projects, regularly advises on property matters, which includes the interface with planning, environmental, regulatory, and ratings issues. In addition to her advisory work on the implications of nutrient neutrality for local authority plan making and decision taking, she's also the contributing editor to Ghana's environmental law on the conservation of habitats and species. Jacqueline, please give your presentation.
Thank you, David. I'm going to sort of start with the basic framework, which is where are we in terms of legal requirements for nutrient neutrality and the consequences that flow from that. So the first starting point is obviously this all comes from the Habitats Directive, especially Article 6.3, and from Part 6 of the 2017 regulations. The critical regulation in this context essentially being Regulation 63. And that's the provision which essentially says that an authority can't grant planning permission for a development or for a plan which is likely to have a significant effect on a European site or a European offshore marine site, which isn't directly concerned with or necessary to the management of the site, unless it's first made an appropriate assessment of the implications of that development or that plan for the site in view of the site's conservation objectives. And that it can only, once it's done that assessment, it can only agree to the plan or project, except in the limited circumstances that are dealt with in Regulation 64, if it's ascertained that it will not adversely affect the integrity of the European site or the European offshore marine site, as the case may be. And obviously this has been the subject of quite a lot of consideration, both at the CJEU and domestic levels, and the principles are pretty much well established. But the most recent substantive consideration of these requirements has been the Court of Appeal decision in Wyatt during the course of last year. And this was a challenge to a grant of outline planning permission granted by Fareham Borough Council for housing development around 5.5 kilometres from the Solent Southampton Water SPA. And in substance, there was also really a challenge to technical guidance that had been provided by Natural England to relevant councils on dealing with the nutrient neutrality issue that had been identified in respect of protected waters there. And in particular, the technical guidance had identified this concept of nutrient neutrality as being one way to address the existing uncertainty that there was around the impact of new development on the designated site, and went on to set out an approach to calculating nutrient budgets for, say, new housing development or other developments that might affect the water quality of those protected sites. And essentially saying, if you follow this approach according to the methodology we've set out, and you get to a point of nutrient neutrality, we think that that's enough to provide sufficient and reasonable certainty that the development does not adversely affect the integrity of the site by reason of the proposed development, although also making clear that had to be tested through the habitats regulations assessment of the developments. And the technical guidance set out 4 stages that had to be undertaken when you were calculating a nutrient budget for development, if that development was going to be draining the mains network. Stage 1 was to calculate the total nitrogen derived from the development, which would then leave the wastewater treatment works. First being 4 steps to be taken. First being to calculate the additional population arising from the development. Secondly, to look at the water use. Thirdly, identify which treatment works the development going to drain through. And fourthly, calculate the total nitrogen in kilograms per annum that would be coming out of the wastewater treatment works after the treatment as a result of the proposed development. Stage 2 was essentially adjusting the nitrogen load to account for existing nitrogen from the current land use, so looking in particular at the before and after on the basis that current land uses would stop. So any nitrogen from those land uses would stop and be replaced by the new development. Thirdly, then adjusting the nitrogen load to account for the land uses in the proposed development. So this was taking into account things like that there'd be a certain amount of the development that might be open space, other parts that might be residential, some parts that might be woodland, things like that. And then fourthly, calculating the net change in the total nitrogen load that would result from the development. And the issues that really arose in this case were largely around stage 1 and stage 2 in particular. So on stage 1, Natural England had provided advice to do with occupancy rates and how you should go about ascertaining occupancy rates for a proposed development. And the issue sort of arose in this case around the starting point that was recommended of a national average national occupancy rate of 2.4. That was a starting point, but Natural England going on to say that competent authorities could choose to adopt bespoke calculations tailored to the area or the scheme, rather than using the national population or occupancy assumptions where they were satisfied that there was sufficient evidence to support that approach. But obviously make it clear, if you do a bespoke calculation, you've got to make sure the evidence base is there to remove all reasonable scientific doubt as to the effect of proposed development on the site concerned. And on stage 2, there was advice around agricultural land. So assuming if you're in a situation where there's going to be housing, say, put on what was previously agricultural land, and trying to calculate what the nitrogen load would be from the existing use could be modelled using the farm scoper model, and the reference there being to if it fell within a particular farm type that's used by the farm scoper model, then you could use the modelled average nitrogen loss from that farm type. Stage 4 was essentially you need to put in a precautionary buffer here. A precautionary approach, you need to put a buffer in to allow for the fact there will be uncertainties in the calculations that have been done. And so the advice was it's important precautionary buffer to use to recognise the uncertainty of the figures, and recommending a 20% precautionary buffer be built into the calculation. So Fareham did the appropriate assessment using the ONS occupancy rate, using the farm scoper data, and applying a precautionary buffer of 20%. Natural England was consulted, didn't raise any concerns about what the council had done or the figures they'd used, and the claimant put in an objection, raising issues to do with the potential impact or the way the council had gone about assessing the potential impacts of the proposed development. And 2 key points that were pulled out was that there was no evidential basis explaining a 20% buffer, so that the use of a 20% buffer appeared to be irrational, and also raising concerns about the fact that the council had used the 2.4 occupancy rate when on another development elsewhere, albeit for a different type of development, the council had used an occupancy rate based on the 2011 census data rather than the ONS. And if you use the 2011 census data for the housing development in this case, it would give you an average occupancy rate of 3.4 rather than the 2.4 that the council used. Again, Natural England consulted again, didn't raise any concerns. The officer's report addressed these issues, and then planning permission was granted. Decision was upheld in the High Court. The Court of Appeal said it was content with the council's approach, at times on slightly different grounds to the High Court. But the guidance that's come out of it is what I focused on in the next couple of slides. So firstly, on ground 1, key point that the court stressed was that technical guidance is guidance, not statute. It doesn't create legal tests. It's not mandatory or prescriptive of a single correct procedure to be followed. And that was particularly important in terms of the occupancy rate. It didn't prescribe that you had to use, or you always had to use, the 2.4 occupancy rate. That was the starting point. It didn't preclude other approaches if it was in the council's judgment right to take a different approach in a particular case. As to the council's use of the occupancy rate of 2.4 in this case, the court was satisfied it wasn't unlawful, and stressed that the question when the court's looking at the test and requirements that apply in this context, it's not about whether every individual figure used in the appropriate assessment is intrinsically the best scientific knowledge when considered on its own, but the court's got to take a holistic view on the question of whether the assessment methodology as a whole represents best scientific knowledge. They also stressed that Natural England had been consulted but not raised any concerns about it. So overall, the court took the view it was open to the council looking at it holistically and looking at the precautionary nature of several of the factors factored in, but the occupancy rate was appropriate or was consistent with a sufficiently appropriate precautionary approach in that particular case. On ground 2, which was looking at the use of the averages, the farm scope for averages, the court was satisfied there was no objection in principle to using those average figures to calculate baseline levels of nitrate deposition from the existing use of the site, and felt that nothing in Dutch nitrogen, which was the case that started all of this off, implied that the use of averages was inherently objectionable. That there may be some cases where it's okay, there may be some cases where it's not okay, but ultimately whether it's all right in a particular case is a matter of judgment for the competent authority. And on ground 4, which was the precautionary buffer point, again, it's sort of picking up on this holistic point. It's not a legal requirement that every element that you put into an appropriate assessment is based on arithmetic or algorithm. And they did actually explore quite a bit into the witness statement, explaining the judgment that had gone into the recommendation of 20% in the Natural England guidance, and concluded that the fact that it was not based on arithmetic but on judgment didn't mean it lacked the adequate basis when you're looking at it in the habitats context and the test to be applied there. And quite importantly, so the fact there was disagreement between experts didn't automatically equate to evidence of serious scientific doubt about an appropriate figure for the precautionary buffer. So just pulling all of that together, firstly, there's again, in the Court of Appeal judgment, there's a useful overview of the key principles that apply in this context. But in terms of what new comes out of the case, a couple of headline points. There's no support in the legislation or authorities for the proposition that the fact that the water body at issue has an unfavourable status raises or alters the level of certainty that's got to be achieved when you're carrying out an appropriate assessment under the habitats regulation. That was part of an argument that had been advanced by the company. You needed to be even more certain because this water body was one that was in an unfavourable status already and needed to be improved. And also there was an argument that was raised that, well, for there to be sufficient certainty, particularly in that context, they've got to assess the reasonable worst case scenario. And that the Court of Appeal felt that in that case, on the judgments made by the High Court, yes, he was the judge in that, Mr. Justice J was entitled to be satisfied in the facts of those cases, that you didn't have to have demonstrate or be satisfied that you had assessed the reasonable worst case scenario if the precautionary principle was to be satisfied, looking over all of the factors that have been taken into account and how it's been approached. So the takeaways from the case are the fact that this holistic approach that I've referred to, it's overall whether or not the assessment methodology has represented the best scientific knowledge. It's not a stage by stage, figure by figure test that's got to be applied. Secondly, that considerable weight was given to Natural England, having considered and raised no concerns with the input assumptions used by the council. So again, they're stressing the need to make sure that Natural England has been given the necessary information, has had the opportunity to comment on things. Thirdly, that the council had explained carefully why it took the approach it did and why it considered the approach it had adopted was sufficiently precautionary. And fourthly, that there's no hardline rule that an appropriate assessment requires assessment of a reasonable worst case scenario in every case. And just to highlight in that case, that the Court of Appeal made clear that the guidance that the High Court have been assessing and that they've been looking at on the appeal had in fact been overtaken by some revised guidance that had been issued in March 2022. So that's where we've got to in terms of what have you got to do on an appropriate assessment. But there has been an issue floating around for a little while now, since the guidance started coming out on nutrient neutrality around subsequent consents and decisions. What do you do where outline planning permission or even reserve matters approval has been granted for a development? And then there's guidance from Natural England raising a concern about the impact of phosphates or nitrates on a water body that's within the catchment area for the development. You haven't done, you've maybe scoped out the need for an AA, or it's been done but without knowing that there was a concern about nutrients. What do you do if there's still decisions that have got to be taken on either reserve matters or discharge of conditions, even discharge of conditions at reserve matter stage? And there's certainly been some guidance that has been circulating suggesting that, well, no, you can't do it at that stage. Outline planning permission or planning permission, that's when it's got to be done. You can't go back and revisit it at a later stage. But now we've had some much clearer guidance, which seems to, so all of which is in the direction of that's not right, and that it can be required for an AA to be carried out at that later stage, even if it's not been done when the outline planning permission or even reserve matter approval has been granted. And there's three things I want to pick up on here briefly. Firstly, and this is only dealt with quite briefly in that case, there was the High Court decision in Swire. Secondly, there's the guidance that's come out from DEFRA and DLUHC in summer last year. And thirdly, a recent appeal decision which has had to deal with this head on in respect of development down in Somerset. So firstly, on Swire, this was a case where the council granted outline planning permission for a mixed-use development. There'd been a challenge to that, but that had been unsuccessful. Following the grant of outline planning permission, the developer had made an application to vary a number of conditions to reflect a change on some access arrangements, and had also applied for approval of details of a master plan under condition 8. So that was on the development side, but separately, Natural England had updated advice to LPAs on the potential for increased wastewater discharge in the Store Valley catchment to adversely affect the Stodmarsh designated site. And with the same advice, that one way to deal with this is to require new development to achieve nutrient neutrality. And the claimant sought to JR the decision to approve the details of a master plan on a number of grounds. There was also a separate JR of a slightly different decision that was dealt with at the same time. But on the master plan and challenge, they included the grounds the council failed to carry out an HRA before approving the master plan. And the court dismissed challenge on that amongst other grounds. There's also quite an interesting consideration of EIA, but that's for another day. And they noted a number of things that Natural England had been in the loop on this again, had raised this as a potential issue on a response on the Section 73 application, but only went so far as to say that further information would be required. Didn't raise any objection to the application being challenged. And there was a series of correspondence going backwards and forwards for which the court felt was clear that Natural England regarded the issue, this potential impact on the water body, as capable of being resolved by the mitigation measures indicated for the site. And also that they were content for it to be dealt with under applications that would need to be made for approvals of reserve matters. The court also identified they'd not seen anything from Natural England raising an objection in principle that couldn't be addressed by mitigation, or that this needed to be dealt with before determining the condition 8 application. And also in the background, the council and the developer had said the second HRA was being undertaken that would address the nutrient neutrality issue. And picked up on the fact that there were these previous authorities, Wingfield in particular, and NOAD, Addistral Newtown Limited, that made clear that you can carry out an HRA at a later stage if it becomes apparent that one is needed and hasn't been done, or if in Wingfield mitigation measures have been taken into account prior to the decision of people over Wing. So that's the you can do it at a later stage if the problem comes to light. There's also been the written ministerial statement and the letter to chief planners in July last year. The text here is from the DEFRA WMS. It's pretty much identical to one of the letters to chief planners, but essentially again saying no, actually, again, you may have to do an HRA at a later stage including reserved matters or discharges of conditions, and a couple of indications where that might happen, again, sort of reflecting the things discussed in Wingfield. Something's been screened in, now can't be taken into account, or where environmental circumstances have materially changed since the previous decision, and indicating there'll be some updated planning practice guidance on that coming forward. This has been picked up in a recent appeal decision published in November. Phase 3 of a multi-phase development in Somerset. Outline Planning Commission reserved matters approval given for phase 3, but there were some conditions that needed to be discharged. And the council said, well, we can't discharge them because there needs to be an HRA in light of that Natural England then issued guidance saying that there could be an impact here on the Somerset Levels and Moors Ramsgate site. So didn't determine the applications for approvals under these conditions attached to reserved matters. Approvals, a developer appealed against non-determination, essentially. And the main issue that was held to be determined was whether or not an appropriate assessment had to be carried out, and if so, what needed to be done. The inspector was pretty clear that an AA was required. I've set out on there a couple of slides that the inspector's reasoning and the things he found. Felt the Natural England advice note could be interpreted as applying to discharge conditions, had regard to the written ministerial statement in that regard. There was an issue about this, whether or not they apply to Ramsar sites, which weren't within the definition in the HABS regs. We felt it was as a result of paragraph 181 of the MPPF. Rejected the argument that requiring an appropriate assessment would amount to reopening issues that had previously been settled. Was concluded that Regulation 63 applied to the discharge of conditions stage, and felt that the approach that the inspector was taking was unaffected by the EU withdrawal. So it's worth a read because it covers quite a lot of the arguments that have been floating around for the past 18 months or so. I've set out on these slides sort of some 3 key points on the inspector's reasoning on why he felt, looking at the regulations, that AA could be required at that later stage. What I should just say here is that I understand a challenge, there may have been a challenge made, or certainly one that was intimated at the end of last year to that decision. So this may well be a watch this space and see whether we might be getting a court decision in due course on this particular point. But for the time being, what we've got is this decision, and we've got the guidance we've had from DEFRA and the chief planners. And what I've just provided on this last slide is some useful links, so including the WMS and the letter to chief planners, and also to where the Jerston Farm decision can be found. With that note, I hand over to David.
Thank you, Jacqueline. I'm dealing essentially with what's happened in parallel with Wyatt, that is to say, the efforts by government through DeLuc and DEFRA and Natural England to address the issues of nutrient neutrality. I've just set out on the first page as an aide memoir. Jacqueline's covered the Wyatt case and its follow-up in particular. It's worth noting that, to add to my list, and I apologise for missing it, Alex's case of Sahota, which was heard by the Court of Appeal at the end of last year, which underlines the fact that a local authority may legitimately decide not to have an appropriate assessment, but Alex will be dealing with that, so I'll say no more about it. The requirements preserved, of course, under the Withdrawal Act, subject to the retained EU law revocation reform bill, which you may have read in the press, proposes to revoke all EU-based instruments automatically at the end of this year, with a final sunset provision for designated instruments mid-2026, unless there is an order by an appropriate authority specifically preserving it. And alongside that, it revokes what little is left of the supremacy of EU law principle, the general principles of law, and whilst it allows designation of specific instruments, of course, it remains to be seen if this bill goes through, and as you'll be aware, it is highly controversial, and the government faces difficulties in the House of Lords in the very near future. Anything that is preserved becomes known at the end of 2023 for some reason as assimilated law. The other parallel developments that are occurring are in the Levelling Up and Regeneration Bill, which has caused controversy both in itself and in terms of the proposed amendments to the National Planning Policy Framework that go with it. But for present purposes, you need to have regard to the amendment introduced in the Commons by Michael Gove, which seeks to amend the habitats regulations, which will introduce via Schedule 12 to the Act, if it passes, which I assume it will, propose new regulations with regard to planning decision-making and plan-making, which require planning authorities, when making habitats assessment, to make an assumption that wastewater treatment works will meet the relevant pollution standards by the relevant upgrade date. And this is all a bit complicated. You've then got to look at the amendments to the Water Industry Act, which LERB proposes in the previous clause, clause 153, which applies the definition in then proposed section 96E, which is either the 1st of April 2030, or if the catchment is not designated as one within the first 3 months from royal assent, then is in a rolling period of 7 years. Now, that's clearly intended to remove the logjam of housing applications and perhaps other developments impacted by protected watercourses which aren't in favourable condition, and to try and sidestep some of the issues which nutrient neutrality seeks to address. That assumption applies unless the Secretary of State directs otherwise, following consultation with relevant bodies. And it may surprise you to hear that an obvious consideration is spelled out in this provision, that the Secretary of State, in so directing, must in particular have regard to when the plant can be expected to meet the standard. The explanatory notes don't explain how this squares with the general need for certainty under the regulations. For example, what happens if the upgrade date is still some years away? In other words, it might be 6 years away or 5 years. Or if there is clear evidence, absent a direction, that it simply won't be met and harm will be caused to the watercourse. And I just note at the moment there is a proposed amendment before the House of Lords Bill Committee to address that particular issue, but I imagine the government will oppose it. Now, the initial guidance that Natural England issued in respect of a number of catchment areas was seeking to build a bridge between solution to nutrient impact, particularly in terms of eutrophication of watercourses in a number of specific catchments by adopting an approach which would secure that the development in question, principally house building, would not make the situation worse. In other words, it would be neutral so far as nutrient impacts on the particular watercourses were concerned. It wasn't intended to be mandatory, and I've quoted a little bit from the earlier Stodmarsh guidance. It's to address the uncertainty that exists until greater scientific knowledge is available. All of those individual guidance documents were replaced by national guidance, which was issued in March, just before the hearing in Wyatt, which allowed us to put it before the Court of Appeal, so at least the Court of Appeal was aware of the changes being proposed, although essentially the national guidance is based very clearly on the earlier versions. Affects 27 catchments and, you know, 76 local authority areas. It's worth noting that these matters are not set in stone, as the guidance itself makes clear. And in August and September of last year, Natural England confirmed to Dover Council, for example, that because of a study that had been carried out showing the extremely limited hydraulic connectivity between the Stodmarsh SPA and Ramsar sites, Dover District Council's housing proposals no longer fell within the need to carry out nutrient neutrality assessments. So evidence can be demonstrated in specific areas to show that there is not a specific issue, and Alex will no doubt deal with part of that in his talk. National guidance is still not mandatory, but it's accompanied by many warnings. This was, of course, the conclusion of the Court of Appeal on the earlier Solent guidance. The criteria for the application clearly relate to the point I just made about Stodmarsh. There must be a source of water pollution identified, or at least a real risk of one, hydrological connectivity with the designated site, and the fact that the designated site's features of interest are sensitive to water pollution. I'm not going to deal with the guidance in detail because what I want to cover is what's happened since. There are 4 stages. You consider the increase in nutrient loading to the habitat site resulting from an increase in wastewater from the new development. And that may be affected by a number of things, not least potential reductions in water usage by development. Secondly, nutrient loading from the past or present land use of the development site. Thirdly, nutrient loading from the future mix of the land use arising from the development. And a calculation finally in stage 4 of a net change in nutrient loading. And the nutrient budget is the net change in loading to the habitat site, which should include a buffer, which I'll come on to in a second. The stage 1 output is stage 2 plus stage 3 and the net change, minus stage 2 plus stage 3, and is a net change in loading to which a buffer is applied. And you'll see this is the detail of stage 1. It turns on a correct assessment of the residents per dwelling if you've got a large housing development, and this is where the dispute arose in Wyatt over the occupancy data, and it makes it clear that the national occupancy average is only one approach, and local relevant occupancy data can be taken, or occupancy rates based on dwelling time. Stage 2 is the calculation, which I've already mentioned. I'd just point out the stage 4 point that I mentioned earlier. Unless the nutrient budget is negative, in other words, it has no effect or a positive effect, seems unlikely in most cases, you add a 20% precautionary buffer. And that is not to render certain that which is uncertain, because you always got to achieve scientific certainty, not absolute certainty in these cases. It's to make sure that any issue in the calculations is properly smoothed out by the application of a buffer to reduce uncertainty from the calculations alone. As a result of the adoption of the issue and of the guidance and the public controversy that arose, particularly with house builders and local authorities who are having to deal with it, who saw it as a burdensome exercise, which it is, a written ministerial statement was produced on the 20th of July, followed up by a chief planner's letter, and you'll no doubt be aware of this, announcing an amendment to the bill, putting a statutory upgrading duty on water and sewage companies by 2030, and you'll see the reference that I made earlier to the date of the 1st of April 2030 in the proposed section 69J of the Water Industry Act. The amendments to the habitat regulations, which I've already touched on, and then a strategic mitigation scheme to be jointly administered by Duluth, DEFRA and Natural England, which would allow the purchase of nutrient credits. And there were various other issues, including the matters Jacqueline's touched on. In August, the Natural England published its technical information note, Nutrient Neutrality Principles. And whilst time doesn't allow me to go into this in any great detail, what it does do is set out a series of principles which can be applied to the nutrient issues, and which demonstrate that the national guidance isn't an exclusive means, but it sets out a series of principles, including obviously reiterating the legal requirement of scientific certainty in any measures that are taken. And I'll just run through very briefly. The second is practical certainty that measures will be implemented at a time and a place which will deal with the effects of the development. That requires careful explanation, and that the mitigation must be in place for the lifetime of the development, which is referred to as in perpetuity. That tends to be, we see, 80 to 125 years. It will depend, I suppose, if you can show what the likely lifetime of the development is going to be. But as they say, it doesn't follow that mitigation isn't needed after the period specified, because it will depend on the development. It creates obvious issues, of course, because you need to demonstrate that the mitigation measures can be secured for that period, which, if it involves measures taken by providing wetlands or something equivalent or some other form of mitigation on land which is not owned by the developer, that there is an appropriate obligation or property right which has been secured in order to make sure that that mitigation is delivered for the relevant period. Oddly enough, there is a very bad, I'd say a typo, I've said it is an unfortunate error in vocabulary which confuses temporarily with temporally, because temporarily does not suggest 80 to 125 years, but assuming that that is an error, and it's made twice, the prevention must avoid effects in the first place rather than offset or compensate for damage. And there's both a time issue and a spatial issue, and you've got to demonstrate when they come, when the mitigation will come online. If it takes time, whether the development can be phased so that the impacts are phased to take account of the time when the mitigation comes on stream to deal with any time lag. And then in spatial terms, you've got to look at the hydraulic connectivity of the site, where it sits in relation to the protected site, and whether it's direct or indirect discharge into the protected water course, because it might be via a series of other water courses, it might be direct. And you'll see that guidance is given with regard to both direct and indirect discharges, and whether it should be upstream or downstream within the catchment. And you see there's also a reference to the fact it may not be possible to provide mitigation on land outside the development, and views given about that. Principles 4 and 7 warn against undermining the restoration of the site to a favourable condition, and 5 warns against double counting measures that are already in place or must be put in place to protect, conserve or restore the site. Now this can give rise, and I'm aware of at least one case where confusion, if not difficulty, has been caused. For example, if measures have been identified in a diffuse water pollution plan or nutrient management plan needed to restore the site, you can't take those matters into account, Natural England says, in order to mitigate against development. So even if those measures that are being put in place will reduce the level of nutrients within the protected water course, you can't rely on that effectively to bring it back up to the level it was before those measures were put in place, although obviously they may have an impact on the extent to which the development impacts on the watercourse. It may be more, it may be less. And I know at least one case in the West Country where Natural England has blown hot and cold, initially saying in a local plan context that the measures could be taken into account, and then saying at the development management stage, no, they can't because it's double counting. So great care needs to be taken with regard to that. The government has issued an update on the 25th of November to its 20th of July statement, saying that the projects that are being taken forward with regard to the mitigation of harm to catchments, starting with the T's, and Natural England inviting applications and developers for mitigation credits before the end of March. This is referred to in parallel by a blog from the Director of Sustainable Development at Natural England. And you'll see I've given a reference to that at the end. It's a blog by Mike Burke on the same day, the 25th of November. It gives rather more detail than the government announcement. You'll see that Natural England refers to the projects in the Tees Valley. And the advice which is given is that you won't actually find out what the terms are for the application of credits until the scheme is launched or shortly before it's launched, which is said to be, as in the government announcement, at the end of March of this year. So details won't be available significantly in advance of the launch of the credit scheme or how it's going to work. But you do get more detail in Mike Burke's statement. Government has also just issued its environmental improvement plan, which walks sort of hand in hand with the amendments to LURB, but you will see that the targets that are set out so far as water quality are concerned and phosphates and nitrates are concerned do not match the because they're there presumably for a different and more long-term reason, they don't match the target dates for upgrades set out in what will be Section 96J and 96E of the Water Industry Act, which are proposed to be introduced that I mentioned earlier. The apex goal is to improving nature, well, fine, and improving environmental quality includes, unsurprisingly, clean and plentiful water. And this includes tackling nutrient pollution, including by upgrading 160 wastewater treatment works and providing increased advice and incentives to support a shift to sustainable agricultural techniques. So the approach looks to tackle both water treatment to deal with nutrients and also look to the agricultural sector to assist. And goal 3, which starts at page 99 of the plan, sets out targets and commitments, which I've set out there. You've got nitrogen, phosphorus, and sediment pollution from agriculture by at least 40% by 2038, compared with 2018, with an interim target, as you'll see, and phosphorus loadings by 80% against a 2020 baseline. No doubt the baselines have been carefully thought out in order to give rise to specific targets. And to deliver the targets, the government states it will ensure water companies are delivering on our targets, etc., increase monitoring, require them to upgrade, and you've got that in the LERB provisions, reduce agricultural pollution across England. A lot of this is all very well. Whether or not this is achieved and what happens if the water companies don't meet the targets and don't meet the interim targets in these goals remains to be seen. And as you know, of course, that ties into an assumption about habitats certainty proposed in Schedule 12 to LERB. And you see further targets set out here. I'm not going to read them out, but it's there for reference. And as I've said, the targets don't equate to upgrade dates. The delivery plan depends heavily on future actions, many of which quite clearly from the language in the plan turn on the development of mechanisms which have not yet been finalised, and none of which appear to provide either currently certain or short-term solutions. And whilst there are many fine words, there's a lot of we will encourage, we will work with, and we'll seek to deal with these matters by a discussion with industry and agriculture. Well, as I say, fine words, and we all hope that it will improve the environment and the ecology that's being sought to be protected. But government is clearly walking the tightrope between trying to do something about the pollution caused by nutrients and also, on the other hand, the pressure from the development sector and from local authorities trying to meet housing targets, which requires some considerable amount of difficulty, and the slight degree of now you see it, now you don't approach, which is inherent in the amendments to the habitat regulations in Schedule 12 by deeming certainty when certainty may well not exist in actuality. And I've given you a series of references, which include, as you'll see, the blog by Mike Burke, which gives the greater detail about the launch of the credit scheme next month. Thank you very much. And can I now introduce Alex Goodman? Alex is an established practitioner in environmental and public law, and I'm delighted to say he will be taking silk next month in one of the latest batch of new silk appointments. A few years ago, he had the misfortune to appear in front of me as a deputy judge in a case called Gardner as part of a series of cases he was doing about water pollution and chicken farms, something of which, perhaps fortunately for him or perhaps fortunately for me, I have absolutely no recollection, but he tells me it's true. Most relevant to today's talk, as I've already mentioned, is his recent activity in the Court of Appeal in the case of Sahota, which was a challenge to the grant of planning permission for agricultural development on grounds of cumulative impacts to the River Wye SAC, where the local authority, I think, had decided not to carry out an appropriate assessment. Alex, over to you.
Thank you, David. Yes, I've been asked to talk about the Sahota case. This was a case against Matthew Henderson, who's also in Landmark Chambers. And in fact, he was asked as the victorious advocate to give a talk, but he wasn't available. So I'm having to speak to a case I lost. It was a case in the Court of Appeal, handed down in December by the lead judgment was by Lord Justice Singh, who gave the judgment of the court comprising Lord Justice Arnold and Lord Justice Lewis. And it's all to do with pollution from nitrates and phosphates to the River Wye. The River Wye, the whole river, is a special area of conservation. So it's all about Regulation 63 of the Conservation of Habitats and Species Regulations 2017. And it took the form of a challenge to the grant of planning permission for the erection of a cattle shed near to and within the hydrological catchment of the River Wye special area of conservation. And there were two issues by the time the case came to the Court of Appeal. The first was whether the judge in the High Court, who had dismissed the claim, had erred in admitting the evidence of Mr. Bissett, who was a council's ecology officer. The second was whether the defendant, the respondent in the Court of Appeal's Planning Committee, had been misled into believing that there was no need for habitats regulation assessment by virtue of the failure of the planning officer to consider or advise on cumulative impacts of the multiple developments across Herefordshire, both in agriculture and in housing, in loading phosphates and nitrates onto the River Wye. The officer compiling the report to committee had considered the council's ecology officer consultation response, which had been given in August 2019, and transcribed that response into the officer's report. And the report advised that, giving effect to those officers' words, there were no likely significant effects on any relevant SSSI that had been identified, and there were no further ecology comments on this development. That's all the ecology officer said. The planning officer then went on to advise the committee, noting that the site is outside the River Wye SAC, there are no other triggers for a habitats regulation assessment process, and there are therefore no likely significant effects on the relevant SSSI. And then there were transcripts of the committee meeting which showed that councillors in the committee meeting had queried the lack of cumulative impact assessments, but had been told simply by the ecology officer that ecology had raised no objection. So just to give a little background, the River Wye SAC has been recognised by Natural England, Natural Resources Wales and Herefordshire Council and Paris Council to be in trouble for a number of years. In particular, the integrity of the SAC is threatened by phosphates and nitrates and other nutrient loading. The SAC itself encompasses the river and its banks. The main sources of these pollutants are what Natural England calls point source and diffuse water pollution, so sewage and agricultural runoff. So in relation to sewage, there are in fact quite strict policies now across the county for development of housing and commercial developments. Other sources include water runoff, road runoff, urban runoff, etc. What was an issue here was manure being spread across fields as part of agricultural practices. The manure gets washed off down slopes into watercourses that ultimately reach the River Wye. In relation to this, the appellant, as part of the claim for judicial review, obtained expert evidence on hydrology. Now, this was because originally the defence raised was that the site was not within the hydrological catchment of the River Wye. And the expert explains that, in simple terms, the whole issue is that when manure is spread within the hydrological catchment area, the rain causes that to run off, in part as surface runoff. The manure is nutrient rich, and it is this increase in nutrients which causes the problem with the River Wye SAC. I have concluded that all of the land on which the manure is being spread, i.e. on the farm in question, is within the hydrological catchment area of the River Wye SAC. Notwithstanding this, on the council's case, some of the land is in the purple shaded area. I'll explain what that is in a minute, which leads to the conclusion that even on the council's case, some of the manure spreading areas will potentially cause problems in the River Wye SAC. I'm therefore unclear as to why an HRA wasn't carried out. Another part of the background was something called the position statement, the council, Herefordshire Council's position statement. And that explains, so that was actually brought in after August 2019, when the Ecology Officer gave his comments, but before the Council's committee considered the application. And it, in the position statement, commits to habitats regulation assessment, which has that rather confusing meaning because it means both screening for appropriate assessment and appropriate assessment. So both the statutory and non-statutory processes that the UK uses. And it commits to undertaking that process for two areas. One is shaded red on a plan and one is shaded purple. And the two areas combined encompass about 2/3 of the county. The quirk with this site was that the red line area was drawn in a very narrow, small part of the farmyard in which a new barn that was going to allow an intensified farm was going to be built. But actually all the impacts that were of concern, the manure spreading, took place on fields surrounding it. Now the fields surrounding were all within the purple area, but the red line wasn't. So if the red line had been drawn differently, the council would have gone through automatically its processes pursuant to its policy. But because the red line was drawn so as not to encompass the area of impact and only the area of the development of the barn, the council didn't treat it as within the area where mandatory habitats regulation assessment is undertaken. There's also of relevance a position statement prepared by Natural Resources Wales. Now, on the Welsh side of the border, because the River Wye zigzags across the border and in fact comprises the border, so you can have fun canoeing down it, zigzagging across from England to Wales. On the Welsh side, they adopt a precautionary approach with a position statement for the whole of the Welsh area. So the whole of the county of Powys, for example, is covered by this position statement. Natural Resources Wales is the partner body to Natural England on that side. And so the policy there is that new development within any part of the catchment which will increase the amount of concentration of wastewater effluent or organic materials discharged directly or indirectly into the catchment's water bodies has the potential to increase phosphate levels within the water bodies. Any proposed development within the Wye catchment that might increase the amount of phosphate within the catchment could lead to additional damaging effects to the SAC features, and therefore such proposals should be screened through a HRA to determine whether they're likely to have a significant effect on the SAC condition. Once issued by NRW, this position statement in combination with the compliance assessment report applies to all development. And it concludes, a large number of water bodies on the Wye are failing their phosphate targets. Even where they are passing, there is generally little headroom. For this reason, we are unable to rule out the possibility that additional phosphate input on any part of the River Wye SAC will further damage the SAC, and we therefore recommend that any proposed new development that might otherwise result in increasing the amount of phosphate within the SAC, either by direct or indirect discharges, must be able to demonstrate phosphate neutrality. So that was another part of the background. So against that background, you've got Herefordshire, where 2/3 of the county has to be screened. You have the Wales situation where the whole of that side of the border has to be. And then you have this site, which is slightly within and slightly without those policies. The claim was that the proposed development would involve the expansion of livestock farming, a consequent increase in manure production and resultant spreading of manure on the fields that surround the site, and a consequent potential runoff into watercourses, which increase the nutrient loading on the River Wye. In fact, the development site is at the very centre of the catchment as defined by Natural England. Development was of a specific kind noted in Natural England guidance as being of concern, agricultural development involving intensification of cattle farming, and the council had erred in failing therefore to undertake appropriate assessment. That was the challenge. The issues The omission of council evidence issue, that's of less relevance to us today, but I set out what the argument was. Essentially, it was said that the council, having produced these very limited reasons in its advice to members, couldn't try and make good the omission with ex post facto evidence from an officer who, moreover, was not the decision maker. He simply was a consultee. So he couldn't give evidence of the council's reasons. Furthermore, it was said what was in his mind was never communicated, and the evidence he gave was inconsistent with the advice communicated to the officers. All of those points were rejected by the Court of Appeal. The second issue was about the failure to undertake appropriate assessment. The council didn't undertake appropriate assessment, and the advice given simply was that the site was not within the SAC, Special Area Conservation. Of course, that was inadequate advice because intrinsically a development can impact on an SAC despite not being within it. And it was submitted, the flaw was exacerbated when at the committee meeting, members queried why there was no cumulative impact assessment. Clearly they were used to that in other areas, and were simply told that there was no objection from ecology. And so the submission was consequently the failure to conduct an appropriate assessment was itself Wednesbury unreasonable. And I've included in the slides just a reminder of Regulation 63, 63.1, a competent authority, before deciding to undertake or give any consent, permission or other authorisation for a plan or project which is likely to have significant effect on the European site, must make an appropriate assessment. That's the main principle, and that gives effect to Article 6.3 of the Habitats Directive, as you've heard. And so one looks to some of the jurisprudence of the Court of Justice of the European Union. And in this context, the so-called Dutch nitrogen case is particularly on point, because that confirmed that cattle rearing and the application of fertilisers may be classified as a project on which Article 6.3 bites. And they set out some of the principles at paragraphs 98 to 101. Principally, the assessment carried out under the first sentence of Article 6.3 cannot have lacunae. At 100, Article 6.3 thus integrates the precautionary principle. At 101, it is for the national courts to carry out a thorough and in-depth examination of the scientific soundness of the appropriate assessment within the meaning of Article 6.3. And in paragraph 102, they went on to say that it should be noted that under Article 1E of the Habitats Directive, the conservation status of a natural habitat is considered to be favourable when its natural ranging areas it covers within that range are stable or increasing. I've set out some of the main principles, which I think have now been covered off. So by both Jacqueline and David's talks, but just three of the main ones that came up as to unlawfulness. And the claim here relied on some of the prior authority, particularly the Attorney General's, the Advocate General's speech in Sweetman, which again informed the Champion decision, which is the only Supreme Court level decision on this area so far. And what was said there is where competent authority's decision fails to make an appropriate assessment of likely significant effects, its decision will be unlawful if there are likely significant in combination effects. Secondly, the informal threshold as to the appropriate assessment must be undertaken is a very low one. And thirdly, a competent authority may lawfully decide to not even bother to check whether appropriate assessment is required, where it's obvious that the purpose of undertaking appropriate assessment is already met. And part of what was at issue in the Court of Appeal was what the obvious category encompasses. And for the appellant, it was said it encompasses things like a change of use within an urban environment, which could have no conceivable connection to polluting the river, not to agricultural development of a very kind covered by guidance as being a principal source of pollution to the river. But the Court of Appeal disagreed ultimately with that submission. So there have only really been two I would say, successful challenges to failure to undertake appropriate assessment. They were Cumberledge, which was a case of agreed mistake of fact about the scope of a sort of a precautionary zone around an SAC, and the Wealden case, Miss Justice Jay's judgment, which was a case of a misstated legal test. So there's slim authority that's in favour of quashing decisions on the basis of appropriate assessment. This was an attempt to create a third that ultimately failed. The principal prior authority on which this case relied was a case called Smythe, in which Lord Justice Sales said that if you had a case which involved the mere assertion or by an expert, unsupported by consideration of any background facts and without any reasoning to explain the assertion made around the risks to the SAC, if such a case arose, evidence of that character could fairly be described as merely subjective. Well, I set out what the advice to committee was. It was a single line, in effect, unsupported by consideration of any background facts. And so the submission was that this case was that very example of such a rare case. But the resolution of the case was to admit the council's evidence and therefore to admit its reinforcement of its decision. And so the court held that the error alleged was that checking any database to ascertain whether the red line of a development fell within a zone was not dispositive of the decision, and that the advice given that the site was not within the SAC was insufficient, and there was therefore a lacuna. But the court gave fairly summary reasons dismissing the challenge and held the appellant's complaints did not amount to allegations of a public law error and were in truth a disagreement with the evidence, and that such a disagreement was not a basis for a challenge. So classifying it as one of those merits challenges which does not amount to a public law error. And so there is an onward appeal, but it doesn't have permission yet, but it's been filed in the Supreme Court, and it raises as the primary issue to what standard must a decision by a competent authority that a development is not likely to have a significant effect on the European site be made, where that conclusion leads it to not to trigger appropriate assessment. And then three sub-issues: did the Court of Appeal properly direct itself in proceeding on the basis that the reasons given in evidence by the consultee could be imputed to the committee? If the court was right to treat the consultee's officers' reasons as a basis for the committee decision, did it nonetheless err in failing to quash the decision on the ground the consultee's officers' evidence did not show the respondent had dispensed with appropriate assessment to the proper Waddensey standard? It's referring to the decision of the CJEU. And what's the proper approach of a court to satisfying itself of the scientific and legal soundness of a decision to dispense with appropriate assessment? And did the court fulfil that duty? But thank you very much. I hope you may have some questions. You can submit them in the Q&A chat. I'll hand back to David.
Many thanks, Alex, for that. We've got a couple of questions which seem to be directed to my paper, but I'd like to ask Jacqueline a question first, which is about the contentious issue of subsequent approval, appropriate assessment. And I'd just like you, Jacqueline, to just give us a little more as to how you see this as panning out in terms of it as a principle. And I say that with a certain degree of interest in the matter, having put all of this in the notes to the habitats regs in the Planning Encyclopedia last year, supporting the government's view, but that doesn't commit you to supporting it.
Thank you, David. I mean, it's $1 million question, isn't it? I'm very conscious whatever I say now could completely be cut across by what comes out in the next policy document, or indeed the High Court, if the Jerston Farm matter does end up being dealt with there. I mean, it's difficult to see, in a way, why it shouldn't be appropriate to require an AA at a later stage. if the need for one crops up as a result of a change in circumstances or a change in the legislative legal requirements or something coming to light that is just wasn't known about at the time the outline permission was granted, given what the purpose of the habitats regulations and the directive was, which is to prevent there from being an adverse effect on integrity of the site. If something comes to light, it seems very strange to say, well, now we know there might be a problem, it's too late for us to do something about it, even though we've still got further decisions that need to be taken. That does seem to me an odd conclusion to get to in light of the purposes of the legislation and what it's designed to protect. I think the question is how is this circle going to be squared going forward? Because obviously we're getting the mood music coming out of government is they want to try and streamline these things to try and prevent housing being held up by the need to carry out assessments or put in place individual mitigation. We know that we've got the bill that you talked about, David, in your talk about potentially knocking out to one foul swoop all retained EU legislation, which would capture the habitats regulations unless modifications happen. We know there are changes or reviews that are being looked at for the HABs regulations to deal with how do we deal with this, and there's also the sort of then against that there was what was being talked about at the end of last year about these environmental outcome reports and ongoing monitoring requirements and making sure that we maintain at least the same level of environmental protections we've got now. So it's not entirely clear how this is all going to come out in the wash. But
well, it's I mean, it's one of the oddities, isn't it, that you've got these proposed changes in LERB Schedule 12 deeming certainty to be met, although those deeming provisions are uncertain in themselves in some respects. But at the same time, you've got the retained EU law revocation bill on the stocks, which suggests that to some degree government is clearly accepting that it has to retain the habitats regs in some form, because why bother with LERB if you're going to revoke it all?
Yes, I mean, that might lead to a bigger question about joined up thinking around bits of legislation that are coming forward at the same time, because I know there have been some inconsistencies that have been picked up between LERB and other bits of legislation that are kicking around, I know, in the last couple of months. But I mean, I think where the big fight might come on all this is obviously a lot of it's been driven by the proposed interpretation point, and even where language doesn't necessarily fully square on a literal, when you bring in the purposes, you get to what seems like the right conclusion. It does seem like that might be a pretty key point of attack in the bill. And I think that could be where we see some quite interesting developments happening if the bill does go through in its current form, when these sort of questions come to the court. If that's enacted, what do they do then? Yeah.
And I mean, one of the interesting things is the Office for Environmental Protection gave evidence to the LERB Bill Committee in the summer before Michael Gove came back into office and introduced the amendments which we see in Schedule 12, which weren't in the original bill. And the OEP's evidence, which is available on Hansard, obviously, suggested that there might be habitats problems even with the outcomes report. So I know the OEP is going to advise government on the proposed changes to environmental assessment and habitats in due course, but it remains to see what they're going to say. Let me just answer, before coming to Alex, let me just answer the questions that have been put up, which are really directed to what I was saying. Yes, I agree that if you look at the government's environmental improvements plan and at Natural England's guidance, that these are directed to conservation or nature-based solutions, both in terms of what is going to be required of landowners and what is going to be required of agriculture. That said, there is also a degree of engineering involved in the upgrades that are going to be required to water and sewage treatment works. And it's quite clear that they don't rule out the prospect of larger sites building their own engineered solutions, say in terms of water and sewage treatment. And in fact, that would be consistent with what Natural England has said in its technical advice, the one with the vocabulary error from last summer. And also, if you look at the blog relating to the Natural England test projects in the Tees, etc., on the 25th of November, what is said is that if there is an over-subscription for credits, and you can see that happening, of course, quite easily, that priority will be given to the delivery of housing, particularly affordable and social housing projects, but it will also be given to small and medium enterprises, so I'm just getting the words right, that it said usually find it harder to access on-site mitigation. So if there is a rush for credits and there aren't enough to support all the development, the larger sites look as if they're going to have to fend for themselves if there's a conflict between priority and the scale of the development. Turning to some of the other questions, the credits being available only within the specific catchment, I honestly don't know the answer to that, because what Natural England has said is that it will tell us what the terms are of the credits and the application criteria at about the time they launch them. So we're still waiting to see really the detail of that. And all we've got is that latest blog, which doesn't really help very much. But equally, dealing with the third question, the question of where the site mitigation has to be in relation to the catchment, it doesn't have to be in the same local authority area or necessarily the same water water company boundary, because what's important, as the technical note indicates, is how the development site relates hydraulically to the protected site. Is it indirectly feeding into it through a series of watercourses, or is it directly feeding into the protected area? And I don't think that can logically or scientifically turn on where you sit within the local authority's administrative area or the water company's area. And therefore it is and must be possible to deliver mitigation out of area, but it comes back to having to show certainty and having to secure the mitigation. And one of the difficulties that may arise, of course, is you'll have to put in a planning application to deliver the mitigation as well as the site. Alex, I'm going to stop talking for a second and just ask you about Sahota. How do litigants take forward these cases if they are genuinely concerned, as your clients were in Sahota, about what the planning authority's done?
Yeah, before I answer that, David, there was a very recent appeal decision that I saw going around in Billingshurst in Horsham District Council, where someone had managed to use a dairy farm they owned in order to get mitigation for a different site. So I think it can be done, just picking up that third question. The clients in this are benefiting from an Aarhus costs cap. So when you bring a claim in environmental matters, you can apply for a cost cap, and if you get it, your exposure to adverse costs is limited to £5,000 if you're an individual, or £10,000 if you're an organisation, unless it turns out that you're of very significant means, in which case it can be varied. So that's one advantage, and the other development really over the last few years is that this originally was funded just by a group of locals who helped the claimant out, but as it's gone on, they've managed to broaden the ambit through more national crowdfunding. So that's quite a new sort of development in environmental litigation, which facilitates those sort of public interest type claims.
Yes. Thank you. Jacqueline, we've got a question whether retrospective regulations are likely to cause havoc with existing sale contracts for land for development.
I think the short answer is yes, they might well do, particularly if you're dealing with contracts where the value or the price is yet to be determined, or even in contracts that's gone through that might have overage provisions in them. If they're linked to things like land areas or developable areas or things like that. And I know, David, this is something that we discussed at the land use conference back in the autumn of last year, that particularly where there might be a requirement to deal with on-site mitigation or take out areas of land that have been proposed for housing or other value generating development, and to retain it as open space or woodland, or essentially mitigation for the nutrient issue, that could well start cropping up in sort of disputes around price or obligations, even potentially to complete, depending on how the contracts are drafted.
I mean, a related point in relation to how you proceed in real property terms is the question which asks whether a landowner, house builder, lease land to meet off-site nutrient neutrality requirements until there has been the appropriate upgrade to wastewater treatment works, or perhaps or at least until the deeming provision comes in and provides the necessary deemed certainty. And would those be part of the conditions for phased development? I think the initial reaction is a planning obligation rather than phased development, but I don't know whether either of you have any views about that.
That was my thinking on looking at the question, that this might be something you secure by Section 106, particularly if it's only intended to be a pending, in the short term sort of solution to the issue, and it's expected to be replaced by something else at a subsequent date. Yeah,
Alex, do you have anything on that? No. Okay. The other thing that a local authority might do, at least belt and braces, is some form of condition precedent, Grampian condition, although those require consent these days, which requires the arrangements to be in place and secured in a particular way before the development can be commenced or before it can be occupied. I mean, the technical note from Natural England from August says that it may be possible to phase the provision of mitigation where it's occupation that's giving rise to the problems because of the discharge of wastewater, and it may be possible to phase that development to meet the coming into effect of the mitigation. So it looks like Natural England accepts, at least in principle, an approach which is adapted to suit the individual site and the individual development, so that the mitigation is effective even if it's phased to meet the development. It doesn't necessarily need to be in place on day one, but it needs to be secured in order for the development to proceed. I mean, I have had difficulties for a number of clients persuading some officers at Natural England, perhaps less up to date with this than some of those dealing with the more central advisory parts of Natural England, who've struggled with some of these issues. But the technical information note seems to me to acknowledge a number of the issues which can be dealt with in a slightly more flexible way, providing the overall objective is met. So I think that technical information note, although difficult in some respects, for example, the double counting, is helpful in others. We've also been asked whether further regulations that the government introduces could cause an existing outline planning permission to expire. Do either of you have a view on that?
I suppose what that's trying to get at is if you couldn't then subsequently negotiate a satisfactory discharge of reserved matters, is it? So you're bringing in a new issue, and presumably if there was no way of mitigating the harm, then that could arise in that interim position, as now could be the case in these particularly European type issues.
Jacqueline, from my recollection, and I know you had some involvement in at least a couple of these cases, one of the arguments that is being run by those arguing in favour of there being no power to require an appropriate assessment at a subsequent approval stage is that it could run again contrary to the principle that a reserved matters or conditions approval can't go back on the principle of development. Is that right? Have I recalled that correctly?
You have, and that was one of the arguments that was looked at in the Jerston Farm decision that I mentioned. And I think in that case, it looks like the issue might have been able to be sidestepped slightly because there had already been a discharge, I think, of a condition requiring a site-wide drainage strategy, which was attached to the outline planning permission. So something that was raised is requiring an AA at this stage after a reserve matters approval on phase 3. Could that cut across something that had already been approved under a site-wide condition attached to the outline planning permission? But the suggestion seemed to be on the facts that no, it wasn't likely to reopen that or fundamentally alter something that had already been approved. And it didn't go to the principle. It was about how you mitigate, as opposed to does this entire development become unacceptable in practice. But it may be that was able to be dealt with a relatively light touch because of what the factual situation appeared to be. You can sort of see a bigger issue potentially arising, say if it's the first consideration of this after you've had outline planning permission granted, and outline planning permission sort of granted it, say, for up to 1,000 houses. The only way to deal with it might be on-site mitigation, and that in principle might mean you can only have 600 or something. I'm throwing that out as a sort of speculation off the cuff, so please don't quote me on that. But you can, I think, envisage a circumstance where, depending on when it crops up and how it crops up, you might have something that looked a little bit more problematic in terms of whether the output of an AA could actually mean that the development couldn't go ahead if it was not capable of being mitigated because of X, Y, and Z. But I don't think that's cropped up on anything that I've seen so far. But it's hard cases make bad law, don't they? It might depend on what gets to the court first.
I'm just trying to find my commentary in the planning encyclopedia, because my recollection is when I looked at this last, is part of the difficulty with the argument about not stifling the outline planning permission is that the cases that are relied upon are dealing with the construction of specific permissions, and it's only a construction presumption rather than anything else. And looking at the cases which are the basis for the principle that in general reserve matters, etc., shouldn't undermine the planning permission, it gives way, I think, to hard-edged laws such as the habitats regs and the like, which impose higher duties than simply effectively a type of construction duty. And just to answer the last question, because we're going to have to end in a moment. Yes, there are cases where the mitigation might be available, but it takes so long that the planning permission expires. I mean, that's, I'm afraid, again, another hard consequence of having to do these matters. Like a lot of permissions, you may have a series of conditions which have to be discharged before commencement, and you may run out of time because, of course, you can't commence lawfully until you've discharged your conditions precedent. So it is possible that the lack of mitigation available or the availability of a credit may cause the planning permission to expire and require a resubmission with all that that entails. Well, look, yeah, sorry, Alex, go on.
Well, I mean, all of that, as you would obviously know best, David, is well established in the EIA context, and it would seem difficult and surprising if the AIA context didn't have the same purposive approach to be taken. So it seems pretty likely that subsequent issues that arise between outline and reserve can stymie it, notwithstanding the general principle that you shouldn't go back to the principle after the outline.
Yes. So, as I say, I think we've got to draw stumps at this stage. Apologies for the cricketing metaphor. As I say, if you, I've done a lengthy commentary on this particular issue, which predates the case Jacqueline's been talking about. But if you want a more detailed discussion of that, if you go to the commentary to part 3 of the Habitats Regs, I think, is it part 3 or is it part 6? No, it's part 6 of the Habitats Regs. You'll find the issue of subsequent consents, which raises Alex's point as well, dealt with there. Meantime, can I thank on your behalf Alex and Jacqueline for their interesting and useful papers and comments, and can I thank you all for attending. Please remember that a recording of the seminar will be available shortly, and copies of our slides will be circulated. So thank you all very much. Thank you.
Thank you.